I'm at Boltz, and with me today I have Lee Roland, one of our attorneys at the firm, and we're going to be talking about the Chapter 13 plan that we have in place here in the Eastern District. So, Lee, give us a little background how the new plan has come about over the last few years.
Well, the new plan's come about because there was largely a move to make it a more uniform plan by the adoption of a national plan last year. And with that national plan, it had some things that certain jurisdictions did not prefer. And so what we saw was an evolution of jurisdictions adopting their own plans based on some of their more local preferences. And so with our first introduction of the plan, it was a good start, but there were some issues with certain fields that were largely unnecessary. And so we saw this evolution with a new plan that sort of streamlined things and also made the rights of debtors and creditors more clear.
So a lot of these changes we're going to see are simplifications, really, in many ways, to clean up and eliminate a lot of the unnecessary information that was just extra work for us when we prepare a case and wasn't really helping anybody because they were the standard anyways.
Yes, and with regards to that simplification, what we see is more of a shift from things that were unnecessarily included in the plan and just incorporating a reference to the administrative guide. That way it cuts down on the paper, and there were largely some things that weren't really relevant for the relation between a debtor and a creditor and the agreements in this plan. It was largely due to certain trustee requirements and things such as that, things that just didn't need to be included in the Chapter 13 plan.
In addition, this is with the new plan, we've seen a real change here in the last 2 years in how the Eastern District gets plans approved by the Bankruptcy Court and the process for that. It used to be that the trustee would prepare the plan and file that with the court.
Correct. The trustee would move for confirmation, and one of the issues with that was, based on the Bankruptcy Code, the Chapter 13 plan, it is the debtor's plan. It is the debtor's plan to propose. And as a result, the confirmation should really lie in the hands of the court versus the trustee moving for confirmation, because to the extent that there was something that, say perhaps a trustee didn't prefer, that trustee may not move for confirmation, and then you get a delay in the payments that need to go to creditors. You've got accrued interest that accrues because prior to confirmation, there are no payments that are being distributed until a plan is confirmed and set in stone. That's when payments are made to the creditors. So we don't want accrued interest accruing, and this new change basically involved, it put a general time frame because the code does require that the confirmation hearing be held within a certain time limit, and it gets plans confirmed quicker, and it's more of a standard process, and I think it's effective for the expectations of both a debtor and a creditor.
And it also, Lee, right, it gives us a greater degree of control over the plan so that we can propose new and creative solutions when our clients need those, rather than having to vet them and get the permission of the trustee. We can propose them, and if the trustee doesn't agree, we leave it up to the Bankruptcy Court to decide as the ultimate decider in these cases.
Correct, because the Bankruptcy Court is the ultimate decider in these cases.
All right, let's talk a little bit about some of the more recent technical changes that have gone into place over the last couple months with the Eastern District plan.
Yeah, one of the technical changes that I prefer the most is that one of the issues that we have, and one of the benefits that Chapter 13 brings to clients, is if a client owes more on a vehicle, let's say, than the vehicle is worth, and they've owned that vehicle for more than 2.5 years, we can pay the fair market value of that vehicle versus paying, what is the over-secured amount. And with that benefit also comes a change in the rights of a creditor, and it needs to be spelled out in the plan as to what those rights are and what we can effectively do under a bankruptcy plan. So this new plan, what it does is it lays out those rights, and it just basically says the payment, the lien must be released either with the payment of the underlying debt under non-bankruptcy law, basically based on the contractual terms, or when a discharge is entered, to the extent that we are paying the fair market value of that claim. What that does is, in the event that we do not have a creditor that is releasing the lien at the end of a discharge, we have a specific provision in the plan that we can point to explain how they were treated, and the fact that this was the confirmed and this was the plan that was enacted.
And so the advantage for our clients on that is that gives us some teeth at the end of the case, so that if they're having difficulty getting the title to their car or their mobile home, or even in some circumstances their paid off mortgage,
Correct.
It gives us some ability to enforce that and go after the creditor for not complying, because that's a problem we've often had in the past, where somebody they've done everything they're supposed to, the client,
Yes.
and they want the title to their car because now it's 5 or 7 years old and they want to sell it or trade it in, right? Or give it to their kid for a starter vehicle or something like that. And this lets us force the creditor to do that. And if they don't, we can then also seek damages probably at that point.
Absolutely. And there are a number of federal and state law provisions that we can use to add to these teeth, but we really don't like to do that. We want the client to have the lien released on their vehicle, and we want that client to enjoy their fresh start and move on. But this has something specific that we can point to without trying to educate generally a less sophisticated creditor on the intricacies of bankruptcy law. I just want a paragraph I can point to.
There is a degree of balance for the creditor. Does have some protections here also, in that their lien persists until the debtor completes their bankruptcy case, right?
Correct.
So they won't have, even if that car has been paid off earlier in year 4.5 of the case, they may not get, the client isn't necessarily going to get the title to their car until the case is completed. So that's something clients need to be aware of and prepared for as they go forward with their Chapter 13.
Yes, and that's largely a fairness provision to protect the creditor and their lien and the rights that they have against that vehicle. The debtor must fulfill the promises that they entered into with filing of the Chapter 13 plan.
All right. Another change, Lee, that you've mentioned to me is that in some Chapter 13 cases, debtors have to pay money to their unsecured creditors, their medical bills, credit cards, things like that.
Yes.
And that can be based on their income, their assets are the main reasons why that would happen. But the new plan makes some changes to protect against having to overpay those when we can you describe those for us a little bit?
Absolutely. There are two ways that a debtor would have to pay their unsecured creditors. One of this would be based on a certain income level, and the other would be based on the equity that they have in property in order to protect that property. And so when we have those situations, those require a payment to unsecured creditors. But when we don't, based on a debtor not having that income or that equity in property, there's no requirement that debtor compensate unsecured creditors. And what we do as a practical matter to protect our clients from unnecessary attorney's fees and to protect our clients from having to go back and amend plans and incur that expense of amending plans, we generally will put a little bit of a buffer in there, because when the claims come in, we find that accrued interest occurs and that there's more that needs to be paid in these plans.
It may be a mortgage arrearage is higher, or they owe some
Correct.
property taxes, or some debt that we estimated on the low side,
And there's a variety of circumstances that occur, and that's why we largely started putting in the little buffers and putting in a little added extra cushion in these plans so that we don't have to constantly go back and amend them. It reduces transaction costs. It just saves everybody a lot of time and effort.
it helps set the client's expectations more
Helps set client
appropriately.
expectations as well as budget, because we want to get an idea as to what that plan's going to be, and then we want the client to build their budget around that expense. And I think one of the issues that we were seeing is that years down the road, we would have a trustee come back and say, well, based on what was coming in, you had a 2% dividend to unsecured creditors there, and that needs to be maintained in the event that there's attorney's fees for a motion for relief or things such as that. But that's not really required by the code. And so what this provision that is incorporated in Part 5 of the plan basically says is there's no guaranteed dividend to unsecured creditors. If you're not required to pay it based on the equity that you have in property or your disposable monthly income based on your income levels, you cannot hold us hostage to that dividend. That's largely just for purposes of administrative convenience.
That's really good, because that'll help our clients and from being punished for providing a plan that's got that cushion or buffer in it.
Absolutely.
Let's talk about another change that we have now, and this is in regards to leases and executory contracts, which would apply for things like car leases, cell phone contracts, apartment leases, are, we see, people who lease sheds or other rent-to-own property like that. Can you tell us how the plan has changed regarding those?
Absolutely. There was an initial provision that was included in a prior draft of the plan that basically said there needed to be a motion to assume or reject an executory contract or unexpired lease. That's not necessarily in accordance with the way that Chapter 13 reads for the Bankruptcy Code, because the debtor can assume or reject a contract within a Chapter 13 plan. And quite frankly, for purposes of knowing what the agreement between the debtor and all of their creditors are, the terms of a plan needs to be included in a plan versus a separate motion that's sort of to the side of what we're actually doing here. And that's what Chapter 13 envisioned. So now with the adjustment in the new plan, it just basically allows for the assumption or rejection of an executory contract or unexpired lease as a plan provision. So there's one place where we can go to see what the plan entails. And this is consistent with the code. But also one of the benefits that bankruptcy includes is that for purposes of a Chapter 13 plan, if there is perhaps a cell phone contract or an unexpired lease for personal property that was not included in the plan, like perhaps the client just didn't realize that they were in a 2-year contract for a cell phone, or there was some other various contract for a mattress or something that they didn't understand that was included, what the code does under Section 365 is it allows the client to automatically reject, and it provides for the automatic rejection of that unexpired lease or executory contract unless it is assumed. So if something is left off and it's for personal property, it's rejected. And by rejection, I mean that the client is not liable to that creditor.
That doesn't mean that the client loses their cell phone necessarily.
No, not at all.
As long as they make their monthly cell phone payment.
Correct.
Sprint or Verizon will keep providing them cell phone service.
Correct.
But if down the road, for whatever reason, they're not able to afford that or need to break that contract, they can do that without the same ramifications as they would otherwise.
Absolutely. And I think also what it does is that to the extent that a client agrees to assume a contract or an unexpired lease, it gives them the expectations and the understanding that I am reestablishing my liability for this obligation even though I have the option to reject it.
And that would be something that people would then know that they're doing rather than backing into it by accident.
Absolutely.
So
because we want clients to file these Chapter 13 plans and agree to these Chapter 13 plans with full knowledge of what they're agreeing to and the consequences associated with them.
Great. Lastly, I think one of the things that I think is the most useful about the changes in having a local form plan is that even though it has standard provisions that work through what we have to do with different creditors, it does allow us the creativity by always including a non-standard provisions paragraph that can be pages if necessary, right?
Yes, correct.
And so one of the things that we started to do earlier this year after working with the Chapter 13 trustee is we have a bunch of what I call stock provisions. They're non-standard provisions, they're not in the local form, but they're things that we include all the time that apply to how plans are going to be confirmed, how to deal with possible disagreements between us and the trustee or the trustee and a creditor without holding up confirmation. Can you talk about those a little bit, Lee?
Yes, and I think one of the things that is most beneficial in allowing for the non-standard provisions is that we can tailor specific provisions to the circumstances of a client's case. A lot of times what our goal is we're just trying to get to the point where we don't have to go back and amend a plan based on claims coming in higher, and we provide automatically, the difference in our estimation versus what comes in through the court. We can provide for additional attorney's fees. We can provide for things without having to go back to the client and change what the plan payment amount is. One of the things that I probably use the most when we have situations where we are surrendering collateral and we have creditors that are not active in the pursuit of that collateral is giving them a limitation of perhaps, say, depending upon the circumstances, 6 months from the day that we file the case to go liquidate that collateral and amend their claim to provide for an unsecured deficiency in the event that that is something that we have to pay based on income or equity and property. putting a limitation on the creditor's ability to do that, what it does is it, number one, puts a fire under the creditor to not sit on their hands, take an active role in this bankruptcy case. We'll give you what you're entitled to, but do it quickly. Do it within a reasonable amount of time. What it does for the client is it gives them the expectation of this is the time limit within which I have to wait to see whether my plan needs to increase. And it's that kind of control and that kind of tailoring of a plan to a client situation that we really have the ability to take advantage of, and that can be beneficial to the client and a creditor.
Among some of the other non-standard provisions that we're starting to see used more often is the provisions for if the debtor is going to participate in the mortgage modification program, right?
Absolutely.
And there's a standard provision for that that we need to include, because that lets the trustee and the creditor know immediately that this is a plan where we're going to be seeking to try to modify the mortgage to deal with the arrearage and the ongoing payment and so forth. We're also seeing, we have opportunities for dealing more proactively with people's student loans by including provisions regarding that. But
yes.
I think what's really useful in this, the non-standard provisions, is that when we have clients who they don't fit into the cookie cutter box, that we can still take care of them and put the plan payments that they need and construct the situation based on their circumstances.
Absolutely. And the mortgage modification program, what it does is it really gives the client an avenue to seek a modification of their mortgage, but also at the same time it allows for some oversight of that process, and the oversight of that process is within the context of the bankruptcy code and a bankruptcy judge reviewing the time limits and reviewing the interaction with the client.
Great. Well, I really want to thank you for talking about this with us today, and also all the work that you've done, particularly with Best Case and to get our form plan working better, and with the local rules committee. And I think this has been going to be a real benefit for our clients and also make it easier on our staff. So thank you, Lee.
Thank you for having me. It was my pleasure.